And this matter comes before the court today on Plaintiff Frankenmuth Insurance Company motion for summary disposition. I would invite appearance by counsel at this time.
Thank you, Your Honor. Good afternoon. Leah DuRoss on behalf of Plaintiff Frankenmuth Insurance Company, P77166.
Thank you.
Good afternoon, Your Honor. Julian Heidenrich here on behalf of Defendant Falcon Custom Homes.
Thank you.
Good afternoon, Your Honor. Jeff Kelser on behalf of the defendants, the Lemons.
Thank you. All right, and we can proceed at this time. And Mr. Ross, as I read your motion for summary judgment here, you appear to be asking me first to rule that you don't have a duty to defend, and then secondarily, and of course, related is the a ruling that you don't have a duty to indemnify for any damages, including the the one sole element of what I'm going to call damage. It's actually return of a deposit that I've ordered thus far, financial damages that have been awarded in this case. Is that accurate?
It's accurate to a degree. I don't know that it's a first, second thing. The requests were made for both findings of no duty to defend and no duty to indemnify. I think that based on the defendant's responses, perhaps there's a question of fact as to a portion of those, but I do think that plaintiff is entitled to at least a partial summary disposition as to the duty to indemnify as to certain claims and types of damages that are being alleged in the underlying action. And I know that the court has read the briefs and everything, but just to state, in their responses, defendants have not made any comments as to plaintiff's argument that there's no duty to defend or no duty to indemnify as to the claims of breach of contract, violation of the Michigan Building Contract Fund Act, the common law and statutory conversion claims, breach of fiduciary duty claims, and the fraudulent inducement claims. And they didn't specifically address the arguments that there's no duty to indemnify the claims for damages that are purely economic damages as laid out in our motion and brief on pages 13 and 14. Defendants' responses focus solely on the negligence claim and potentially covered property damages claims for same. As to the other claims that weren't addressed, I do believe that Frankenmuth is entitled to summary disposition to state that there's no duty to indemnify as to any damages assessed in regards to those claims or those purely economic damages that are noted on, again, pages 13 and 14 of our brief. As to the negligence claim, I would say that based on defendants' responses, perhaps there is a question of fact that still needs to be decided at that matter. So I'd ask as to those claims, if the court is not inclined to grant our motion as to those claims, that it only be denied without prejudice, so that when the underlying case does, if there is findings of facts as to those, that we can potentially refile this motion with more clarity as to whatever findings of fact were made in that underlying case.
Okay, all right. So it seems like you are at least conceding with conditions, a question of fact, and of course, a question of fact as to the duty to defend, as to any portion will keep Frankenmuth in the case going forward. However, you would like me to put some guardrails around that in regards to what claims there's a hope of indemnification for at the conclusion of the case, all of which is, of course, preliminary because we don't know, if and what a jury might award in the case in the first place. So is that an accurate summary?
That is an accurate summary. I would just add, to which I think you've already referred to, that there has already been a ruling made on to that return of the deposit. And we would argue that we would be entitled to a ruling that we have no duty to indemnify the defendants as to that return of deposit, as that is a purely economic damage that does not arise out of an occurrence, and defendants have made no argument whatsoever as to what portion of the policy could potentially provide indemnification coverage for that claim.
Okay, all right. Let me hear responses. I have read the briefs. Let me hear from Mr. Heidenreich.
Thank you, Your Honor. So Falcon's position in this is, and I think it bears some clarification. There's been a lot of briefing, a lot of long briefs in this one, Your Honor. For that, I apologize, but the case like this is just, it's just going to go that way. So what Frankenmuth is essentially asserting here is that it is completely impossible for there to be any coverage with respect to the complaint.
Well, I think there's been a concession, at least that oral argument, that maybe there's a fact question as to coverage under the negligence claims. I'm wondering specifically, are you arguing that Frankenmuth ought to write a check for that $300,000+ deposit?
I am not, Your Honor. And what I'm trying to differentiate, though, is, and I guess clarify, if there is any inkling that there is a covered loss in the complaint, then there is a duty to defend the entire thing. Not a question of fact as to a duty to defend the entire thing. There is a duty to defend. That's what the case law says. And so, yeah, I mean, with the deposit and with certain aspects of the complaint and the allegations that the Lemons are making in the underlying case, I totally understand Frankenmuth's position on those. But their initial motion, and I acknowledge the concessions, made in the reply and then today, but I think as far as evaluating the duty to defend, when you're talking about the allegations in the complaint, I went through in my response in painstaking detail, citing to the Lemons' underlying complaint in each paragraph where there is a claimed construction defect and property damage. I also cited to all the ways in which those allegations are linked to subcontractor work. So that right there is enough. If even one of those defects, if even one of those subcontractors is covered, the whole case is covered from a duty to defend standpoint. And there is no question as to that. All there has to be is some sort of suggestion and possibility that there is coverage somehow, and that alone triggers the duty to defend under the prevailing case law.
I like your standard of an inkling, Mr. Heidenreich. We'll use the inkling standard
Yes.
in Michigan. It can go right alongside we got rid of the scintilla, I guess.
Yeah.
I guess sometimes you got to get the thesaurus out and kind of let it do its thing, So
you wouldn't be a lawyer if you didn't love some aspects of word parsing. So let me move on to, speaking of word parsing, to the second part of that, which is indemnification. Now, on one hand, if I find that there's a duty to defend, and thus deny that portion as at least premature, there being a fact question as to the duty to defend. And I guess that would, of course, a question about duty to defend and the recovery of the fees expended, etc. Some of that does automatically occur during perhaps a subsequent action for indemnification down the road. Am I on solid ground at this point if I rule that there is no duty to indemnify for economic losses of the types that Frankenmuth identified on pages 13 and 14 of its motion?
Well, so generally, I tend to agree with some of that, although I think a problem comes to mind in that we don't know what damages are going to flow from what allegations at this point in time, except for possibly the deposit issue, which seems to be better defined than really anything else. So if there's any concession to be made on my part, that deposit issue seems like a pretty fair concession as far as an indemnification issue. But when you're talking about where damages are flowing from, as far as what the Lemons are actually claiming, and by the way, the law requires Frankenmuth to look not just at the complaint, but beyond the complaint to find coverage. And so when you're looking at the subcontractor claims that are clearly implicated in the Lemon's complaint, as we now know, having looked behind or underneath the kimono, if you will, to see all the subcontractor work that's been implicated. Those are all occurrences under the prevailing case law. Looking at Skanska, the Skanska case outlines this, that those are occurrences. So to even, it's tempting to even say, for me to say that an I-2 ruling should be made with respect to the indemnification in favor of coverage for those types of losses. Although I think, I'm not here to pound the table on that issue too hard. I think at a minimum, there's a question of fact as to the indemnification for those things. But because there's a question of coverage, this court can rule that there is in fact a duty to defend as a matter of law under MCR 2.116 I2, because that's how this works. If you're in for a penny, you're in for a pound when it comes to the duty to defend, which I don't think Frankenmuth really touches in either their initial motion or in their reply. So I would think that, there's a question of fact as to a lot of things, but the implication of subcontractor work, because we know that those are occurrences under CGL policies like Frankenmuth's policy in favor of Falcon, then there is not only a duty to defend as a matter of law, but also there is at a minimum a question of fact as to those components. And I point out, the other arguments that we're making in my response to the motion. I guess I can leave it at that, knowing that the court has read those things. If the court has any questions about anything else, I'm happy to address them.
No, I think that covers, what I need for today's ruling at least. But I want to give Mr. Kelser an opportunity to weigh in as well.
Well, thank you, Your Honor, and I won't take up too much time with the concessions that plaintiff's counsel has made on some of these issues, and the argument from Mr. Heidenrich. Don't have much to add. I'm in agreement with much of what Mr. Heidenrich has said. Seems to me there's no question that there is at least a question of fact on the duty to defend, so as to prevent summary being granted on that issue. And as to the indemnification issue, I do believe, and I think it's reflected in the parties' briefings, that there are, at the end of the day, there will be certain categories of damages that are economic and not covered by the policy and subject to indemnification. But I think it's simply premature at this time to try to draw a line in the sand as to what those categories are.
Okay, and I take it your clients, the Lemons, like most plaintiffs, should they prevail on all or part of the cause of action, don't care much whose name is on the check, whether it be Falcon, other subs, or Frankenmuth. They just care that it clears when it hits the bank.
Certainly.
Okay, all right. Let me bounce back to Miss DuRoss. Given the fact, and I think, the arguments are on target here because there is a negligence component to this complaint, and that inherently involves, some factual determination about the conduct of the parties during the construction, and there's also that subcontractor, what I think's been referred to as a subcontractor extension of the insurance contract that could trigger coverage for some faulty work done by subs. In this matter, you're going to be stuck with the duty to defend. I'm wrestling a little bit with how to, if any, include indemnification language. I think I'm hearing in general agreement that the deposit that, in my mind, was a contractual amount that was owed. I determined, due to the breakdown of the relationship and the fact that it appeared that some of the deposit amounts remained unspent in the builder's account, that amount should be returned to the Lemons at this point. However, I don't think there's any argument there that amount is due, due to an occurrence, negligence, or subcontractor, anything of that nature. It is just purely a contractual obligation. I am a little bit concerned about if I were to issue a ruling as broad as to say that purely economic damages, as you've described here, are not going to be recoverable, it almost seems like I am inviting additional litigation over what, because I'm very well aware that sometimes it's hard to parse out what are purely economic damages and what are negligence related damages that spring out of there. Some of them may sound pretty economic, when it comes to things like loss of use, for example. Perhaps that is purely economic. Perhaps it's a negligence-based damage. What are your thoughts on any ruling today on indemnification beyond the deposit amount, which I think I'm hearing no one's really fighting back very hard on?
Yes, Your Honor. And I understand that there can be some overlap, and obviously this hasn't gone to trial. We don't have the full finding of facts on everything. I do think that there are some categories, as noted on page 13 and 14, that are clearly just economic damages that have nothing to do with any kind of claims of defective work or anything that could potentially even arise out of property damage whatsoever. And as to those amounts, I think it would be beneficial to the parties just moving forward, just to have some clarity as to those specific claims that there's no potential for indemnification on. I mean, we can go through the list if you'd like, but in general, I mean, there are some things there that are just, there's no way that they are economic damages arising out of an occurrence that would provide for indemnification coverage in this matter. And if you'd like to go through the list, obviously we can do that, but.
Okay. Well, and I take it that me ruling on it at this point would serve some valuable function in that it might, assist your client with, since I'm keeping them in the litigation on the duty to defend, perhaps evaluating their potential scope of liability and participating in, what I'm going to refer to as potential global resolution.
It would assist, Your Honor.
Yeah, that's what I would think of as well in the matter. So, okay, well, I think this has been thoroughly briefed. And I believe in a separate case I've entertained a similar motion for Frankenmuth, and if it's any consolation to you, it was argued by one of your colleagues, but I kept them in the case as well on a duty to defend, and that's largely because the duty to defend, as defined in Michigan, is very broad. It only does require I said I liked Mr. Heidenrich's term in Inkling, perhaps a reference back to the good old scintilla standard in now defunct C10 practice, but nonetheless, the definition of the duty to defend is very broad, and as Mr. Heidenreich also pointed out, very comprehensive in that, unfortunately for insurers, once they're in to defend, they defend all aspects of the claim, even portions of the claim where they may later seek indemnification or a ruling from the court that was not a covered element of damages under the policy. But nonetheless, the duty to defend is broader, and this policy includes several clauses that invoke that, most notably the definition of an occurrence, which I did highlight at one point here, and then there we go, which is deferred as an accident. And of course, an accident is almost synonymous with negligence in Michigan law, and there are negligence claims asserted against the conduct of the defendants in this matter. So potentially that would trigger coverage. Of course, additional portions here are the your work clause, which indicates that work or operations performed on by you or on your behalf, and also materials, parts, or equipment furnished in connection with such work or operations, including, and this is coming out at 22, I think, paragraph 22 of that insurance contract, warranties or representations made at any time with respect to the fitness, quality, durability, or performance or use of your work, and providing of or failure to provide warnings or instructions regarding that work. And then finally, there is a subcontractor extension provided in the contract that indicates that that your work coverage extends to conduct or work performed by subcontractors on the property. There's no doubt that project of this size, all the work was not performed directly by the defendants in the matter, but much was performed by subcontractors, and my understanding is that's now subject to some litigation in front of my colleague, Judge Benson, as to, who is at fault for, perhaps improperly completed or not completed work, whatever it might be. Haven't reviewed that case luckily yet. I may get the opportunity, I suspect, in the future if there's some discussion and consolidation. But in any case, at this moment, it certainly is true that there are subcontractors involved in this project, and that Falcon is alleging that some of the conduct was the fault of said subcontractors, and therefore triggering that subcontractor extension under the policy, and therefore resulting in a duty to defend. So the motion for a declaratory judgment as to a duty of defend, duty to defend, is denied at this time. And that denial, the request is that it be without prejudice in order to potentially trigger it later. However, I do have to agree with Mr. Heidenrich in this case that because, there seem to be sufficient facts of record that would trigger the insurance company's duty to defend at this time. And I haven't been shown any facts of record that may say, there was no duty to defend, and that is such a broad duty that I will make that ruling with prejudice at this time. I do think that a question of indemnification and potentially even attorney fees as a consequence can be raised effectively in the indemnification case, which I am not going to rule on at this time, with the exception of the enumerated categories, and that I will rule at this time that there is no indemnification required for certain categories of purely economic damages. And those would include, and I'm going straight off the list in Frankenmuth's brief on page 13 here, the bullet points: amounts lost due to Falcon Custom Home and Abbott's fraudulent kickback scheme, amounts Falcon Custom Homes and Abbott's collected from the Lemons as fees or otherwise skimmed from project funds that were based on subcontractors and material suppliers' inflated invoices and unauthorized markups. Again, not a defective work claim at all there, but something that was done involving someone's intentional fraudulent conduct. Bullet point 3 says amounts Falcon Custom Homes and Abbott collected from the Lemons as fees or otherwise skimmed from project funds that were based on subcontractors and material suppliers' unauthorized charges. 4 is amounts Falcon Custom Homes and Abbott collected from the Lemons as fees or otherwise skimmed from project funds that were based on fraudulent or fake invoices. Again, all invoking the type of non-accidental conduct, fraud, that would not be covered, and the sort of economic damages that stem from that again, purely economic damages not based on negligence and thus potentially covered. The next bullet point here says, well, and that's one question. The one I'm going to delete is the amount Falcon Custom Homes and Abbott charged and collected from the Lemons for defective work on the construction project. Well, that does bleed into that negligence claim, and I am not going to rule on that category of damages at this time, so that one will be excluded. However, the next one and the following are amounts Falcon charged and collected from the Lemons based on fake or non-existent invoices and or costs. The next one is amounts the Lemons lost and or incurred due to Falcon Custom Homes and Abbott's failure and refusal to return plaintiff's deposit in the amount of $316,622 plus interest, costs, and fees incurred by the Lemons. The next one, Falcon Custom Homes and Abbott's overpayments for the work performed using the Lemons funds. The next one, Falcon Custom Homes and Abbott's overpayments for work to be performed using the Lemons funds. Oh, that's to be performed. I was trying to say it looked like we might have a double there, but I understand one looked into the future. Costs incurred. You know, the abandonment of the construction project, that may again implicate the negligence and other portions of it as to why they abandoned the construction project or whether that happened and when it happened. I'm going to delete that one. However, I will include the next one here, and that is costs and expenses incurred by the Lemons due to Falcon Custom Homes and Abbott's failure to provide all lien waivers and Falcon and Custom Homes Abbott's otherwise interfering with the Lemons financing. The fraudulent inducement claim, the next item there, Lemons damages incurred because of Falcon Custom Home and Abbott's fraudulent inducement of the Lemons to enter the party's construction contract, including not limited to Falcon's fee and its overpayments using the Lemons funds. Those would be, not collectible under the indemnification portion of the ruling, and as well as trouble damages for amounts Falcon Custom Homes and Abbott allegedly converted from the Lemons, as well as the Lemons attorney fees and costs. I'm not going to rule entirely on that question of attorney fees and costs right now. As I said before, I think that it potentially may be addressable under contract and, of course, any other statutory or court rule based claims. So I'm going to rule on that the conversion claim would not be included, with the exception of I don't want to include that attorney fees and costs language there. And those categories all may be excluded from indemnification as purely economic claims at this time. So I guess since that is a partial denial and partial grant of the motion, Mr. Ross, do you want to make an attempt at the order?
I will make an attempt at the order.
Okay, very good. And certainly, if you want to run it past counsel and do that, and my hope in doing the partial ruling and the remainder of the claims for indemnification are denied at this time is premature, pending, of course, more factual development in the underlying case. My only hope in making the order so detailed is to give the parties a little bit of guidance as to how I might rule in a future indemnification action, so that it may aid in the potential resolution of the entire matter, which I earnestly hope for in my fever dreams. So,
Your Honor, if I may, a point of clarification.
Certainly.
So in my response to plaintiff's motion, with respect to only the duty to defend, I moved the court for a ruling that there is a duty to defend under I-2. I just wanted to make sure that was being.
Yeah, I think that correlates with my denial of the motion to say there's no duty to defend. And then I'm granting your I-2 motion. There indeed is a duty to defend, as found by the court today.
Thank you for the clarification, Your Honor.
All right. Thank you, counsel. I'll look for the order, and I wish all of you a safe and maybe we can get some clean air to breathe this weekend. We'll set the bar low.
That'd be nice. Nice to play golf without a mask on or something.
Something like that. That's what I would appreciate it. Yeah, it's been, my filters must be working in my house, because though the courthouse was a lot worse when I went down there, there's a lot of smoky smell in there. So strangely, the courthouse must not be as buttoned up as my own house, even though my house is about 100 years older than the courthouse. So very good. Well, like I say, I'll have a great weekend. I'll look for the order.
Thanks, Your Honor.
Thank you very much, Your Honor. Have a nice weekend.
You as well.